Good morning, everyone. My name is Abtin Bahador. Pleasure to speak with you all today. So as Jennifer mentioned, I'm here to talk to you about how foreign-owned companies can bring workers to the US using e-visas. There are several reasons why I like to recommend e-visas. One, adjudications are far more predictable than with some other classification. There's no cap on how many e-visas are available each year, and there's no limitations on how long a person can hold e-status in the United States. Finally, there are some very creative ways that we can bring workers to the United States, even if your company is not foreign owned. So stay tuned. Uh, Types of e-visas, there's two basic types. The E1, which is based on substantial trade in goods and services between the United States and a country with a qualifying treaty, and the E2, which is based on substantial investment in a real and operating US business by an investor from a country with a qualifying treaty. What countries have qualifying treaties? Well, there are over 80, and there are many that you would expect, such as the Canada, UK, South Korea, Japan, Germany, but also some that you might not expect, like Jamaica, Pakistan, Ethiopia, Honduras. It's important to keep in mind that even if there is a qualifying treaty, not all companies qualify for both E1 and E2. For instance, Jamaica only qualifies for E2. There are two large emissions, which are China and India. Those are not included as qualifying treaty countries. However, Taiwan is included. Um, the company and the individual must have the qualifying nationality to use the e-visas. So how do we show the nationality of a company? Well, we trace the ownership all the way back through all the holding companies, back to the individual shareholders, and look at their passports to show that ultimately individual owners of the company from that treaty country own at least 50% of the enterprise. It is important to remember that permanent residents of the United States, even if they're dual nationals, have nationality abroad, they don't count towards that 50%. Also, typically the country of incorporation, that doesn't matter unless it's a publicly traded company. So, as I mentioned, there's two kinds, the E1 and the E2. We can't cover the requirements and qualifications in depth during this presentation, but we're including some slides with some more information. Basically, the E2, based on substantial investment in a real and operating business. If you already have a business in the United States, then it's likely a substantial investment was made at some point. The E1, based on trade, both imports and exports of goods and services into and out of the United States. And services, it's important to remember, are interpreted expansively. So things like consulting can be included as trade. The important aspect to remember is that the United States must be the primary trading partner. So if you have a qualifying e-visa company, then you can bring employees to the United States. Those employees must have the same nationality as the business and be coming to serve in an executive, supervisory, or as an essential employee. What are executives and supervisors? What do they do? Well, we need to show that they have control and responsibility over the overall operations or a major component of the company. Factors that the agency considers are whether they have discretionary decision-making authority, whether they're setting the policies, directing the business operations, supervising other supervisors or professionals. What are their skills, experiences? What's their title and salary? How do they fit within the hierarchy and organizational structure? As for the essential employees, this is a very flexible category that allows us to bring in a wide array of workers. Basically, we need to show that their skills are essential to the efficient operation of the enterprise. Basically, their skills are needed and that employee has those skills. Factors that the agencies consider when adjudicating whether a person is essential is the uniqueness of those skills, the training required to achieve the skills, availability of US workers with those skills, their salary and expertise, and how long they will be needed in the United States. Ordinary workers, so simple old Joe over in Taiwan, he can come over if he is essential, if he's coming for training purposes or to help start up operations. The skills don't need to be unique or proprietary, one of a kind. We just need to show that they're indispensable to the success of the business. For essentiality, foreign language, knowledge of a culture or previous employment with the employer abroad is usually not enough to show essentiality. However, the stage of the company, what stage you're at, if you're a startup, what's essential is different than if you're a more mature company. So you found the guy that you want and you want to bring him over. How do you get the work authorization? If they're already in the United States, then we can file for a change of status to E1 or E2, but we typically recommend that they apply at the US consulates abroad for an actual visa. They can change their status in the United States, but the next time they leave and try to re-enter, they'll need the visa anyway. Also, the State Department that controls the consulates abroad is primarily responsible for adjudicating e-visas, and they have the expertise. Each consulate has their own specific requirements on everything from the page limits. Canada, you can only include 70 pages, whereas Mexico, you can include 150. The required documents, the procedures for submitting the documents, and actually scheduling the appointment. More and more, the consulates are using the registration programs where the first applicant will qualify the entity, and then subsequent applicants can focus more on the individual employee and what skills they have. So it can become streamlined over time. Typically, the visas are granted for 5 years, though the reciprocity schedules will determine how long each country gets for a visa validity. Once you use that visa to enter, you're typically given 2 years to be in the United States at a stretch. This is a great little provision because even if the person uses their visa a day before it expires to enter, they'll still get a full 2 years to be in the United States. E-visas also are terrific because they are renewable for as long as the treaty or the trade or the qualifying entity exists. The e-visas also allow for employment at the subsidiary level. So as long as we show that the parent subsidiary relationship exists at the time of adjudication, and they're coming to perform similar executive, supervisory, or essential duties, they can't be saying they're a manager and then coming to push the mop for the subsidiary. We can bring them and they can work for any entity within the line. Finally, what about their families? Well, families can come on the e-visa as well. Children under 21 can come as well as spouses. They don't need to have the same qualifying nationality as the primary visa holder. Children can attend school without need for a student status, and spouses are employment authorized incident to status. This means that they have unrestricted work authorization in the United States without needing to apply for formal work authorization. This creates some exciting opportunities. And even if you're not a foreign-owned business, let me tell you a little story. I had a client a couple of years ago of a US employer that wanted to hire a foreign worker. The foreign worker didn't qualify for anything, but his wife always wanted to own a little cafe. So we got a cafe for her set up, got her an E2 visa based on a substantial investment in that cafe, and then brought the foreign worker who the US employer originally wanted to hire on as unrestricted work authorization. And he had a great time just both working in the United States. The other aspect of the e-visa that is helpful is that the E1 available for substantial trade. It includes consulting services. So if you find a foreign national who you can't hire as an actual employee, if he provides sufficient trade in volume or dollar value, typically around $100,000, we can qualify him for an E1 visa, and he can come to the United States, perform consulting services for your US company under that E1. He does need to keep a business abroad that he is, that he is maintaining abroad, but it does provide some flexibility to bring more foreign workers to serve your US company. So that being said, e-visas are very flexible, and I thank you for your time.